So a lot of these challenges are being played out right now in cases before international bodies, and they relate also to particular issues within human rights law itself, such as extraterritorial applicability, that I think, are moving slowly towards some kind of common understanding that not everyone would necessarily agree with, but I think a more comprehensive understanding of how and when human rights law applies extraterritorially, and that is going to help us very much in the future. But also with regard to the interplay between the two of them, we're seeing cases come up now, for example, in the European Court of Human Rights, recently the Hassan case, and soon the Russia-Georgia case, which again might start pointing in certain directions of the interplay between the two and how international bodies are going to do this. My guess, but my guess perhaps is informed or perhaps in certain ways, this is my hope rather than my guess, but let's assume that they're the same, is that we are starting to, I hope, move away from assuming that we have clear legal principles that can be applied top-down and that there's sort of some magical solution to the interplay between human rights and IHL. And with more and more cases and more practice, we're going to see how we try and solve this by looking in particular situations, particular contexts. So that the solution isn't one solution for all situations, but rather the interplay between human rights and IHL will work in a certain way in detention. It'll work in another way in occupation, and it'll work in another way with regard to use of force in a demonstration, and so on. So we're going to have to solve this in a case-by-case scenario, but we're working towards that. And I think once we have that and we have more established practice, hopefully this question will become less of a troubling one in the future.
Where really there is also and will remain a key difference, even if here I'm a bit paraphrasing from other scenarios that have been examined over this expert process, even if during an operation through interpretation and others, the two paradigms might come to similar results. Where there is still a fundamental difference is already in terms of planning, in terms of the kind of equipment and training those conducting each type of operations would have. And therefore it will become more and more important that armed forces, for instance, are trained also in law enforcement ways of dealing with a situation, and also police forces might be confronted with situations that might fall under the conduct of hostilities paradigm. So in essence, you know, on an international level, international law does not take a position who should conduct which operations, and in the reality of today's situation, this issue becomes ever more important to be able to switch between different paradigms, which is not always easy in the heat of the moment. Another fundamental difference is, and this was also addressed today, is after the fact in terms of obligations to investigate deaths that might occur as a result of such operations. So here human rights and IHL still seem to be different, and with regard to human rights, for instance, it is common that the standards are much more stringent than under human rights. But this question of investigating cases of suspicious death or as a result of operations, this is something that where there would need, you know, even more examination in terms of the interplay between those two regimes and how they might converge, or how in armed conflict situations, if one would apply, for instance, a human rights law, how that would deal with some of the practicalities and the realities arising from armed conflict situations.